So I think one way or another, if a U.S. attorney ended up being disbarred, they would probably have to leave the U.S. Attorney's Office, leave that position. But that's only a guess because it's never been happened. But, really, even more importantly, I'm not saying he will be disbarred or this is necessarily a disbarrable offense. What we know is his name was on a motion to dismiss a case involving one of his clients, which, the gross features of that is as unethical as it gets. Now, maybe he'll say, well, somebody else signed my signature. It was an auto pen. I didn't know anything about it. We'll wait to see what kind of nonsensical defense he may try to throw up. But even more fundamentally problematic, Brian, is just because he has a law license doesn't mean he is equipped to be the United States Attorney for the District of Columbia. In a very real sense, it would be like saying, you know what? This guy's got a medical degree. He's never performed surgery, but let's walk him into the operating room and have him perform brain surgery. Wouldn't end up well for the patient. In this case, the patient basically is the people of the District of Columbia and the honest and ethical application of the law, the criminal laws in Washington, D.C. This will end badly.
Glenn, what happens in the event that the prosecutors who are serving under Ed Martin at the D.C. office lose faith in the person who's leading them? So in the event that the prosecutors who compose the vast majority of folks who work there don't agree with the positions being put forward by Ed Martin, and yet they're in a position where he directs them in terms of what they have to do.